Today we're in the State Archives of Florida. This is where we keep the approximately 45,000 cubic feet of records maintained by the Archives. Archives is mandated by law to collect, preserve, and provide access to the official records of Florida state government. The preservation of the official records of the government are important because they help to illustrate the legal basis of the government in Florida and make the state government accountable to the citizens of Florida. And the manuscript records are important to collect because they help to go beyond the official history of the state and illuminate the lives of ordinary people in Florida. The items that we selected today are the most significant, historically important items that we have in the state archives. They're rare, one-of-a-kind pieces, and we chose them today because they help to tell the history of Florida. Florida has a very long history stretching back to, of course, before Europeans arrived in the early 16th century, and the documents that we have today help to tie the colonial period in Florida history, a very long period of Spanish and then British control, to the modern history of the state, one that is more similar to the history of South but has its own unique characteristics. The first thing that we have here, this is actually the oldest item that we have in the collections of the State Archives of Florida, and what you're seeing here is a map, and it's a very unusual map. It's believed to be the first map that portrayed a European city in what is now the United States, and that city was St. Augustine, first founded by the Spanish in 1565 by the conquistador Pedro Menendez de Aviles. Map was published in 1589 and is attributed to an Italian cartographer named Baptista Boazio. And the map portrays an attack on the city of St. Augustine in May 1586 by the British privateer Sir Francis Drake. There's a lot of significant details on the map about the colonial city of St. Augustine. There's a portrayal of the walled city up here in the left portion, some of the fields that were under cultivation. Some other interesting details on the map. All of the ships that you see here along the bottom represent actual vessels that were part of Drake's campaign. St. Augustine was not his only stop. He also attacked Cartagena and then Santo Domingo in what is today the Dominican Republic. The city of St. Augustine was very importantly located for the Spanish. It was along the routes that connected Spain, ultimately with Cuba and other spots in the Caribbean, so it had a tremendous strategic importance. Even because of that fact, it took many years for the Spanish to begin construction on a stone fort to protect the city. That was started in the 1670s and finished in the late 1600s, about 1695. This next document comes from the second Spanish period. Spain retook control of Florida in 1783, following the Treaty of Paris and the conclusion of the American Revolutionary War, and they maintained control of Florida until 1821. The document that I'm pulling out now is a unique piece that helps illustrate the African role in the second Spanish period in Florida. So what we're looking at here is known as a memorial. This is a document written on behalf of a free black settler in St. Augustine by the name of Juan Bautista Wheat. He was also known as Prince Wheat. This particular individual was among the many free blacks in St. Augustine at the time. Spain had, for a very long time in Florida, had a policy of offering freedom to persons of African descent, escaped slaves that arrived in the territory. Many of them came from the Carolinas and from Georgia, so they escaped American plantations and they made their way into Florida. Spain offered them freedom on two conditions. First, they had to at least nominally practice Catholicism, which many did, but mixed it with their own indigenous African beliefs. And the second condition was that they had to serve the Spanish government in the militia. And sometimes that also entailed working on fortifications and other types of duties to the Spanish government. In exchange for those duties, they would be granted their freedom and they would be admitted as citizens on the same standing as white citizens. Although there was discrimination that did take place, they had many of the same rights in terms of the Spanish legal system, the ability to enter into contracts, to own land, to sue and be sued in the courts. Interestingly enough, these rights also extended to black women in Spanish Florida. So the comparison here is that when this document in particular was created in 1795, African people in the United States had very few rights. The vast majority of Africans were enslaved. The vast majority worked on plantations or another type of industrial work, if we were talking about slavery in the North. Now, in Spanish Florida, there was slavery. There were African people that were held in slavery, but the process of them being able to obtain their freedom was much easier than it was in then the United States. This is one example of a document that's part of our larger Spanish land grant series. This is one that illustrates the Spanish policy of granting land to settlers, whether they be black, of African descent, or Anglo descent, or of Spanish descent, in an attempt to build kind of a buffer zone between the Spanish settlement in Florida and the rapidly expanding American settlements, which would, in the years after this document, increasingly pressure the United States and eventually resulting in Florida being ceded by Spain to the United States in 1821. We're going to take a look at the 1825 Leon County Census. Now, Leon County was established in 1824. It was made up of parts of Gadsden County, which is the county to the west of where we are today. And in 1825, they did a census of the inhabitants of this area. So Leon County mostly included Tallahassee, but there were other people in the outlying areas as well. Tallahassee was actually only established a year before this census was made as well, in 1824, the same time as when Leon County was established. And this census lists the 996 individuals living in Leon County at that time. Of that total, about 387 were slaves and 608 were free white people. The census also counted one free person of color. There are a couple interesting things that stand out about this census. Because it was very much a frontier type environment, many of the households are made up of single men, individuals who were here by themselves. There are several large families and then several individuals that had a large number of slaves. Almost a sixth of the total slave population was owned by one person, and that was John Bellamy. And he was the person who had the contract from the federal government to build the road between St. Augustine and Tallahassee that became known as the Bellamy Road. So that's why he had 70 slaves at that particular time. There's also a couple other very large plantation owners here that have more than 10 slaves. And there's a couple heads of households that really stand out. One is a household listed as just 2 slaves, and they're listed as being the only people in that household. And then at least one household that is headed by a woman, which is very interesting as well and stood out in terms of the total numbers. So this is a piece that represents very much a frontier time in the history of Tallahassee. It's the first census of this area undertaken, and it helps us to understand the early development of Tallahassee, especially in regards to the number of free inhabitants in this area and the number of slaves. So we started out with some documents from the colonial period in Florida history, then moved into the territorial and early statehood. We're going to stay a little bit in the early statehood period right now, but then we're going to move into more of the modern period in Florida history. And all of the documents that we have now have a lot to do with the legal and legislative history of Florida. This case dates from about 1850, and it involves an individual known only as Luke, a slave, versus the state of Florida. So this is the entire remaining case file for this case. Now, the backstory on this case was that Luke was a slave of a person named Abraham DuPont, and they lived in St. Johns County. And DuPont ordered his slave, Luke, to go on to another plantation owner's property, in this case, Joseph Hernandez, and kill mules, a couple mules that were going on to DuPont's plantation and eating vegetables and ravaging the garden, things like that. So DuPont gave his slave a firearm, ordered him to go onto this plantation, kill these mules. Well, the overseer for Hernandez, he traced this back to this slave, Luke, traced this deed back to Luke. And then the Hernandez sued Luke, and then also his owner, for the cost of recovering the mules. Now, that might not seem to have been a situation that would provoke a case before the Florida Supreme Court. The issue became whether or not Luke, the slave, had the ability to deny this request by his master. If he, in fact, had the free will to deny whether he could refuse and say, I will not kill these mules, or if that order, because it came from his master, a white man, if he had to in fact execute that order. And this caused quite a lot of problem for the court, because if they were to find that Luke did not have free will and he could not have done otherwise, then it was really his master who was responsible for this murder and then would have to pay the fines. And they were uncomfortable with that position because it would mean that anything done by any slave that was ordered by a slave master, the fault would then lie with the slave master. If they were going to find that Luke could have refused the order of his master, and that slaves, in effect, were not bound to follow direct orders from their masters, this would create also a dangerous legal precedent in Florida. It would, in fact, grant to slaves the ability to exercise their own free will, which in the context of Florida law would mean that that would open up an avenue for challenging the very basis of slavery itself. So the court decided that these questions were too complex, and they threw the case out. Rather than grant Luke the ability to act on his own behalf and therefore open up a legal avenue towards establishing that slaves had the ability to act on their own without the consent of their master, or on the other hand, finding all masters liable for the actions of their slaves. So it's an example that helps to illustrate the position that people of African descent, slaves in the Florida Territory, had, and we know they had very few rights as slaves, but also their very ability to act on their own behalf came into question in this particular case. So the final piece that we have today is an artifact from the era of the Civil Rights Movement in Florida. In the wake of the Brown versus Board of Education decision, in which segregation in schools was ruled to be unconstitutional, many governors and many state legislatures, especially in the South, tried to pass laws to invalidate that Brown decision. So they passed nullification ordinances, saying that this federal law, which has been handed down from the Supreme Court, is now null and void. Or they passed interpositional statements, which were intended in the context of the legislative process, to place the legislature in between the Supreme Court and the people in a particular state to block desegregation from occurring. Now in Florida, this is exactly what happened. Florida followed the pattern of many of the other southern states. Florida was exceptional in one regard, in that the governor of Florida at the time, Leroy Collins, was very moderate on civil rights. He was considered to be among his peers a moderate voice on civil rights. He had prior to this time been involved in the Tallahassee bus boycott, which was a boycott that followed the model of similar boycotts in Alabama that was trying to desegregate buses in the city, and he proved to be a person who was willing to compromise with both sides to come to an agreement. Now, that's not to say Leroy Collins, at this particular moment this document was created, was a full advocate of full granting of civil rights to African Americans. That would be a position that he evolved, and his thinking evolved on that later in his career. Now in Florida, the legislature attempted to pass what they called an interpositional resolution. They attempted it in the legislative session previous to this one here in 1957, but they were dismissed by Collins, he evoking a little-known provision in the Florida Constitution that allowed him to dismiss the legislature. They came back in the next session and passed this interpositional resolution. Now, it's a resolution, it's not a law, but it encapsulated the feelings of the Florida State Legislature on this issue of civil rights in the wake of the Brown versus Board of Education decision. Now, Collins, being a moderate on civil rights, being someone committed to finding a solution to these problems rather than upholding segregation indefinitely, when this resolution came across his desk, he took the opportunity to write his feelings about it. Now, this is highly unusual because this here is a book on the laws of Florida that were coming across the governor's desk during this particular year. And if you look at the other pages here, it's a signature and a signature and a signature. And rarely was there anything else other than the signatures on the pages. But he took the opportunity to write on this page and express his feelings on interposition. And this is what Leroy Collins said. This concurrent resolution of interposition crosses the governor's desk as a matter of routine. I have no authority to veto it. I take this means, however, to advise the student of government, who may examine this document in the archives of the state in the years to come, that the governor of Florida expressed open and vigorous opposition thereto. I feel that the U.S. Supreme Court has improperly usurped powers reserved to the states under the Constitution. I have joined in protesting such and in seeking legal means of avoidance. But if this resolution declaring the decisions of the court is to be taken seriously, it is anarchy and rebellion against the nation, which must remain indivisible under God if it is to survive. Not only will I not condone interposition, as so many have sought me to do, I decry it as an evil thing, whipped up by the demagogues and carried on the hot and erratic winds of passion, prejudice, and hysteria. If history judges me right this day, I want it known that I did my best to avert this blot. If I am judged wrong, then here in my own handwriting and over my signature is the proof of guilt to support my conviction. And that's Governor Leroy Collins, May 2nd, 1957. Now, this statement was important for a number of reasons. First of all, it put Collins very much at odds with the legislature, which was firmly behind the idea of blocking desegregation in Florida, from making the effort on the federal level to integrate public facilities, including schools. It put him directly at odds with the legislature, was firmly behind that idea. It must be understood that in the context, there were no African American legislators in Florida at the time, and there were very few women legislators. So it was mostly a body made up of white men who sought to maintain the power and the institutions of segregation in the state. This was also important because it began to express the evolution of thought in Governor Leroy Collins and his evolution from a moderate on civil rights to a firm supporter of civil rights. After this statement came out, this is his last term as governor. He had no chance of re-election. When he was out of office, became a major player on the national stage in the context of civil rights. This document is important because it helps demonstrate that individuals like Collins, that their thinking on civil rights could evolve. And it did evolve, and they explained as much in later years. And it's also very important because it shows how the place that one of the small things that happened in Florida that was very important in the context of the national civil rights movement. I think especially in the early period, Florida was a very contested land. There were Native American nations, there were European nations, and there were free blacks and escaped slaves all vying for their own piece of control of Florida. And that it took a very long time for not only the boundaries of modern Florida as we know it to come together, but also that struggle for Florida was very long and very real. And that by the time we arrive at the American period, it was far from over. And that when we get into the more modern period in Florida history, that Florida came to resemble in many ways the rest of the southern states. And that we look kind of through the documents that we have here now, attest more to the triumphs and struggles of the people of Florida as they interacted with the legal system, as they interacted with the governor, as they interacted with the legislature, and how all of those bits and pieces, all of those stories help to illustrate the shared heritage that all Floridians have, not minimize the struggles that these people went through, but learn how the past can help us to better understand the problems and things that we deal with today in modern Florida.